Item number 1.
Yes.
It's item number 228 are a connected set of appeals. Oh my God.
Yes.
Well, we have filed another appeal today in the morning, which is the main matter. If I may pray, if your lordships kindly...
Let it be called on. It will be called on just now. Just wait.
Obliged.
My lord, we have taken steps as far as district council is concerned. My lord.
Lordship, I'm appearing for respondent number 3. I'm entering appearance.
Please speak louder.
Lordship, I'm entering appearance for respondent number 3, KHADC.
We are.
2 to 1 into 4 to 16.
You are respondent number 3.
3, Lordship.
Khasi Hills Autonomous District Council.
Lordship will be filing a affidavit, Lordship.
What is wrong with the microphone?
Just speak loudly.
Lordship will be filing a...
You pull the mic towards yourself.
Lordship will be filing a affidavit.
But what is the problem? You see, you have any senior in the matter?
Lordship.
Mr. Chudai, are you appealing?
Lordship, I'm for the state, your Lordship. Respondent number 1, 2, and then 4 to 16, your Lordship.
Khasi is defined where both the parents are Khasi, or either of the parents is a Khasi. The offspring, but and described. All right. Provided the lineage is Khasi, what is to do with the surname?
Lordship will be filing a response, Lordship.
No, response that will create cause delay. Now, suppose somebody is Khasi by birth, by blood. Now, if he uses the surname Tom or some Hindi surname Trina, what is the problem? Yes, Mr. Chudai, please assist the court.
Lordship, in fact, your Lordship, I'll give my example, your Lordship. My title is Shulai. My father's title is Wan. So if I like to take my father's title, your Lordship, there is no harm, your Lordship, because I do by taking my father's title, your Lordship, I'm not losing
Yes.
my tribal identity.
No, provided you fit into that definition.
Lordship, yes, because we follow the Khasi way of life, your Lordship.
Khasi Hills Autonomous District, Khasi Social Custom Lineage Act 1997. Khasi is defined where both parents are Khasis,
Lordship, yes.
or either of the parents is a Khasi.
Deny.
But
Lordship will find it that
where both parents are Khasi is defined differently, described differently. One parent described differently.
Lordship, the definition has been given in Lordship, kindly come to page 59. Section 1. Lordship, kindly have H, small h, Lordship. That is the definition of Khasi. Who is a Khasi, Your Lordship? That has been defined in section, sorry, Your Lordship, section 2H, Your Lordship.
Yes.
Lordship. Kindly see, Your Lordship, H. Khasi means a person belonging to Khasi tribe who may be a Khasi, Jaintia, Panas, Senteng, War, Boy, or Lingam, or who is recognized or deemed as such under prevailing Khasi custom or this act. Then, Lordship, kindly come to page 61 at section 3. On or after commencement of this act, every person born of a legal marriage whose parents are or were both Khasi shall be Khasi of the Kur, Jat, or clan of the mother, or whose mother is or was a Khasi and the father a non-Khasi shall be a Khasi of the Kur, Jat clan of the Khasi mother, if and only if the person and his Khasi mother fulfill the following requirement, namely so and so, Your Lordship. Then, Lordship, kindly see C, whose father is or was a Khasi and the mother a non-Khasi, and the Khasi father and every such person fulfill the requirements specified in clause 1 to 4 of clause B of subsection 1 of this section shall be a Khasi belonging to such Khasi, Kur, Jat clan in accordance with the prevailing Khasi custom applicable to such Khasi father or to such new Kur, Jat or clan as may be adopted under any prevailing Khasi custom applicable to the Khasi father or by Tang Jat. Then, Lordship, kindly see to 2. (78). Section 2, Your Lordship, has been amended, Your Lordship. Lordship, kindly have page 78.
Page?
78, Your Lordship. Lordship, kindly then come to relevant page 79. So many new things has been introduced under the amended act, Your Lordship. Then the clan also, registration of the clan, Your Lordship. That Lordship will find it at section 5.
My lord, in the same page number 79, section 3, subclause J, my lord, of, if my lord will see below, it says Ringbia or Saubhoy.
Oh, yes.
Means the customary practices among certain indigenous Khasi clan in Ribhoi district, where in the case of Du Ying is where, my lord, that is defined also,
Female plant anymore.
where they have no biological female offspring. It says where in the case of Du Ying, the Khasi male member of such family may marry a non-Khasi and his offspring may adopt his clan or title with the consent of the Kpo concerned and duly recommended by the Kur, and they may be deemed to be a Khasi if they fulfill the conditions of being a Khasi. Now for some sections of the people, my lord, they have allowed even to adopt the surname of the father because that has been practiced in the Ribhoi district. Even in some other parts also, my lord, the surname of the fathers are taken among Khasis.
Lordship, kindly see also double A in page 79. That's Senkur, your Lordship. That means a body has to be formed, your Lordship. A clan has to form a kind of organization or a body or association. Double A, your Lordship, at page 79. And then, Lordship, after such formation, it has to be registered as per section 13 of the Amended Act, your Lordship. Lordship, kindly see 13.2. Registration of Dorbarkur or Senkur, your Lordship.
Which sections you have placed?
Lordship, kindly come to page 79. Lordship, kindly have double A in the bottom, your Lordship. After the formation, your Lordship, that means a clan has to have an organization or a body or an association. Then that has to be registered in accordance with section 13.2 of the Amended Act, your Lordship. Then, Lordship, it has to be registered as per section 13.2. Then, Lordship, kindly come to page 82. Lordship, kindly have section 18, your Lordship. Khasi clan certificate, your Lordship. At page 82, your Lordship. So, Lordship, if I'm to apply for a clan certificate, your Lordship.
No, only ST is involved.
Lordship, yes.
No clan is involved here. Is that letter?
No, your Lordship. Can you see section 18 of the Amended Act at page 82, your Lordship?
No, please come. The subject matter of challenge are pages 128, 129. Letter issued, then revoked.
My lord.
That is scheduled tribe certificate, nothing else.
Yes.
Page 120. 120, no, yes. Maybe.
Lordship, my learned seniors having some personal difficulties, Lordship.
Who's your senior?
Mr. T.T. Dingdo, senior advocate, Lordship.
He wants to argue the matter.
Lordship.
Lordship, let them file the affidavit, let the district council, Lordship, since they have challenged the act passed by the district council, Lordship, let the district council file a response.
No, he is appearing for the district council.
Lordship, yeah.
So what affidavit? Whatever act notification rules are there.
Lordship, what if Lordship kindly come to the prayer in the writ petition? Your Lordship kindly have page 49. Lordship, this is the relief claim in the writ petition, Your Lordship. The main challenge is, Lordship, is with regard to section 124 to 23 of the Khasi Autonomous District, Khasi, Lordship. Almost the whole act, Your Lordship, is under challenge.
All right. Then notice has to go to the Advocate General also.
Lordship, yes.
Yes, please take it over. The subject matter of challenge in this public interest litigation. Are sections 1, 2, 4 -23 of the Khasi Hills Autonomous District bracket Khasi social custom of lineage bracket closed. Just check up this whether of lineage is correct or not. Act 1997. So what is it? This subject matter? No, you reframe it in this way. The wideys of sections 1, 2, 4 to 23 of the said act, this act, is questioned in this public interest litigation. Paragraph at the outset. We direct that in the above circumstances, notice of and a copy of the petition be served on the learned Advocate General. Paragraph. The immediate cause of action is this, full stop. Next line. By a letter dated 21st July 2020, by the Undersecretary, Government of Meghalaya, Social Welfare Department, to the Deputy Commissioners, East Khasi Hills District, Shillong, and West Khasi Hills District, non-style. Where it was inter alia stated that the aforesaid act did not prohibit the issuance of scheduled tribe certificate, quotation, to the applicant adopting surnames. Okay, underlined in red, huh? Page 128. Paragraph on 21st May 2024. The same department, through its joint secretary, wrote to the said commissioners that the aforesaid letter dated 21st July 2020 was being withdrawn. Paragraph, as a result of this, we are told that the authorities are not issuing certificates to any Khasi adopting his father's surname or husband's surname. Paragraph. In brief, the contention of learned counsel for the petitioner is that provided a person fulfills the eligibility criteria of lineage and blood to qualify as a Khasi under the said act, subsequently amended in which year?
Amended in 78. Amended in the year 2023, my lord.
Subsequently amended in 2023.
Page 78 and 1.
It does not matter whether the entitled person uses his father's or husband's surname. And on that ground, issuance of the certificate should not be denied. The letter of 21st July 2020 was correctly written and ought not to have been withdrawn on 21st May 2024. Paragraph. we have to adjudicate. On the rival contentions, paragraph. We do not think at this stage for disposal of the public interest litigation, affidavits are required. If affidavits are required at a later stage, we shall call for them. But in the interest of the Khasi community at large, this issue should be disposed of as expeditiously as possible. When your counsel will be available?
4 weeks, Lordship. 4 weeks.
4 weeks. 4 weeks. I will go to the moon and come back. You do the matter. Seventh August.
Lordship.
List is public interest litigation. 7th August.
Notice also will go to learned advocate general.
Sorry?
The notice also will go to the learned advocate general. The notice, Your Lordship.
Notice to the Advocate General, my lord.
Notice to the
No,
advocate general.
you will serve or shall we ask the Registrar General?
I will serve it, my lord. I will let it be reflected in the order. I will serve it, my lord.
The Registrar General of this court will serve a notice of this petition on the Advocate General. Another notice with a copy of the petition will be served upon him by Advocate and Record for the petition.
Highly obliged, Your
Registrar
Lordship.
General only to serve notice.
Highly obliged.
Highly obliged, Lordship.
Item number 2 to 8.
Yes, Mr. Paul.
Well, I was submitting, Millets, another appeal has been filed today, and that is the main matter. If my lords, Millets, direct listing of all these appeals together, Millets, on any date convenient.
Yes, Mr. Pandey.
Any date, my lords, it's convenient.
Millets, would the 28th be convenient to my lords?
30th.
30th, Millets.
Yes.
I'll place the mention memo.
No, is it registered with a number, your appeal?
Not yet, Millets. It is in the process of being registered.
All right. On the pair of Mr. Paul, learned senior advocate, appearing for the appellants in these appeals, let these matters be listed once again on 30th, along with any connected appeal which is proposed to be filed in the meantime.
That's
Obliged.
highly obliged.
Number 9.
Millets, I am instructed to appear on behalf of respondent number 3.
Yes.
This is that airport matter, Millets, where there was a reference made by the Honorable Supreme Court as to the quantum of compensation that had been paid.
Yes.
Subsequently, my lords, the matter came before my lords, and
Went to the district judge and
district judge has rendered a finding, Millets. Millets, the finding is that the compensation is adequate, Millets. There is no extra amount that has been paid. What we've done is, Millets, for the convenience of this honorable court, we've prepared a small compilation, Millets, of the relevant papers, so I don't have to burden your lordships with what must.
My lord, the learned amicus he's out of station, my lord. Mr. P. Obin, who's conducting counsel for this matter.
who?
Mr. P. Obin, he's the learned amicus in this matter.
No, but Where is Mr. Chakraborty? Chakraborty was also appearing.
My lord, I'm here.
Yes. You were also appearing in this matter.
My lord,
One of the
I am
respondents.
one of the
Respondent.
number 2.
My lords, if my lords kindly have a look at page 5 of my compilation, paragraph, internal page 4, my lords, second paragraph. This is the orders of the Honorable Supreme Court. What was the point of reference, my lords? My lords have it. Well, it's the first line, my lords Macalici. The only other issue which survives is whether the public money has been squandered as suggested by offering higher rate of compensation, which is against the rate offered by the owner or the rate at which she purchased just before acquisition. So this was the issue, my lords, that
That is at page?
well, it's page 5. This is part of the judgment and order of the Honorable Supreme Court, my lords. This is dated, the judgment and order is dated 2nd August 2017. And at page 5, my lords, is the relevant part.
Yes.
Second paragraph, first line, my lords.
Yes.
Now let's have it. If my lords, if I may, they come to the next paragraph, my lords. We request the Chief Justice of the High Court of Meghalaya to nominate a district judge to determine the matter as far as possible within 3 months from the date of receipt of a copy of this order. Order so and so. Any parties interested in the matter are at liberty to put forward their claims. So this was the issue, my lords. And my lords, I'll now take your lordship straight to the finding. That would be at flag F of this compilation, my lords, which we filed. Eleven, you want me? Straight to the conclusion. Well, I can take your lordship straight to the conclusion before I take my lords to the details. It starts at page 73 of this compilation.
Yes.
May I read, my lords? With the above observations, I am to conclude as follows, that the sale deed dated 13/1/15 for an area measuring 10 acres and bounded as follows did not confer any title on claimant number 3 of the plot of land. Let's then again may not be relevant. Well, I can just skip all this because these would not be issues that were for determination. Well, page 75F is the relevant finding, which was the first point of reference. If my lords have it, my lords. The compensation of rupees 115, rupees 115 only offered is not excessive and has been calculated as per section 26 of the Act. This answers the reference, my lords, that had been made by this Honorable Court.
No, but the other findings are also important.
Well, I can take your lordships through to the other findings.
Because I suppose one of the issues is that one who did not have a title has transferred the land and taken the money.
Lordships, that was one of the issues. What I was humbly submitting before your lordships is that the reference, my lords, by the Honorable Supreme Court was on the issue of whether excessive money has been paid or not. And that is the issue, my lords, which your lordships have subsequently also held. Now, if, my lords, the money is not excessive, the only issue then arises, my lords, who is entitled to the compensation. So for that, my lords, the respective parties would have to, my lords, take their own recourse under law. I can read the entire thing, my lords, if your lordships so permit me. At B, my lords, at 74, if my lords,
No, if you come to page 4 of the judgment,
my lords,
internal page 4,
of the Supreme Court judgment.
yes. Question as to who is entitled to the compensation may also require consideration.
May require consideration, my lords. That's what I'm saying, my lords. So the amount which has been paid is not excessive, my lords. That is settled. Now, just, my lords, if I may just turn the page over, my lords, at page 4, last line, if my lords kindly see. Because she's one of the claimants, my lords. My idea is not to stop anybody. The idea is, my lords, that if anybody is entitled to any relief under law, my lords, we will have to approach a competent court. At page 4, my lords, last line, if my lords can you see, as regards the claim of State Dakhar that the sale deed on her behalf was not genuine, such an issue can also not be gone on to us in view of the fact that State Dakhar has already received substantial payment and no grievance was raised by her till filing of this appeal in the court. So, my lords, insofar as that claim is concerned, my lords, the matter comes to an end over there. But, however, my lords, what your lordships have rightly pointed out, that question as to who's entitled to the compensation may also require consideration. That aspect, my lords, what I'm humbly submitting before your lordships is, since the compensation is not excessive, who is entitled to the compensation, my lords, is then an issue that would have to be, my lords, sorted out between the claimants, respective claimants, before a competent civil court. The special judicial officer, my lords, does not give a finding to that extent. As a matter of fact, my lords, the findings are, if I can take your lordships to page 74, my lords. My lords have it. My lords, the sale deed of 13/1/2015 for an area measuring 10 acres and bounded as follows did not confer on title on claimant number 3. So this issue settles that, my lords. The unregistered sale deed dated 1/9/2015 for an area measuring 6 acres and 26 acres bounded as follows did not confer any title on claimant number 2 over the said plot of land. A bare comparison of the boundaries of the land which has been acquired and the boundaries of the lands based on the documents relied on by the claimant number 1 with boundaries so-and-so, my lords, I'll skip, and PWD road are entirely different and do not bear any semblance of similarity in boundaries or area. The land of State Dakhar claimant number 1 as per her document dated 13th June 2015 on the boundary on the east is not contiguous to the defence land or the PWD road as per the survey map. Similarly, the boundaries of the 10 acres of land on which the claim is based does not bear any semblance of similarity in area as well as boundary on the land acquired by the government and found to be beyond the acquired land. The claimants could not establish that the land covered by the deeds documents relied upon them has been acquired by the government. Thus, a fresh survey ought to be conducted by the government to ascertain the actual owner. That aspect, my lords, cannot be done by the learned special officer, my lords, in terms of the reference made by the Honorable Supreme Court and this Honorable Court. But the finding, as your lordship say, that, my lords, it is also suggestive that nobody is there. So, if at all, my lords, anything is to be done, then we'll have to approach a competent civil court. All the parties would be at liberty, my lords, to establish our title before a competent civil court.
You are the appellant here.
No, my lords, I am one of the claimants. I am the person, my lords, who was added as a party before the Honorable Supreme Court, my lords, and my assets were taken at the time when the order was passed.
Oh, this is a PIL.
This is a PIL, my lords. This emanated out of a challenge made to the acquisition before the Honorable Supreme Court, my lords. Honorable Supreme Court said that with regard to the acquisition, we are not going to interfere. There's one plea that was raised saying that excessive money has been paid. To that extent, my lords, this reference came into being.
So this entire money has been paid.
Money has been paid, my lords. Some might, 80% has been paid, my lords, 20% is not paid as yet. That's what I'm instructed.
This comes rooted through a PIL.
The airport PIL, my lords, which my lords are hearing.
And which went to the Supreme Court.
My lords.
That is also SLP from PIL.
Yes, yes. What had happened is, my lords, there was a direction for acquisition of certain
Mr.
land.
Paul, please try to appreciate that this is not a regular reference by the district judge under the Land Acquisition Act.
My lords.
Can we or can we not say that this is to be taken as a judgment and order or judgment or decree of a district judge, and the remedy is a first appeal before the higher court?
Well, it's the only issue here would be then with regard to the finding at C.
Whoever wants to appeal.
Well, it's the finding at C says, well, it's nobody's entitled to anything. She's basically saying, well, it's the land which has been acquired is not even the land of any of these three claimants, is not even the land which has been acquired. This, my lords, in my humble submission, was absolutely outside the mandate of what was, my lords, the original requirement under the orders of the Honorable Supreme Court. If at all, my lords, there were two issues. One, whether there's excess payment, and as your lordships have rightly pointed out, if there is a dispute, my lords, who's to get the money?
Yes.
If, my lords, I then
Now,
take it,
he who has received 80%,
my lords,
was he entitled to receive it?
that's the issue which ought to have been answered over here, my lords.
So that will be answered by that has not been answered by
That's not been answered. If at all, my lords, that was an issue that I humbly submit, my lords, that may not have been an issue.
No, because Supreme Court says that phrase, that small phrase is there, that
If at all, my lords, it's to be paid to. At page 4, as your lordships have pointed out.
yes. So we can send it on a limited remand.
My lords, your lordships, this 3 inquiries have already come.
Because this question has not...
I think this is the 3rd time, my lords, this report has come before my lords.
So if this judgment is not questioned, it is all right. Is anybody questioning this
My
judgment?
lords, I think all of us, my learned senior is also here. At the first instance, my lords, my learned senior had also submitted the same thing, that we can go back to, my lords, a respective civil court to establish our titles if at all.
Lordship,
No,
I
but-
have a small submission, Your Lordship.
No, who has taken the money? Whose client has taken the
My
money?
lords, I represent that one of the beneficiaries, my lords.
So 80% you have received.
Yes, my lords. Out of which a part of it has been paid to the state Dakar, which my learned seniors represent.
No, but what happened exactly here?
My friend is representing state Dakar.
Number 2, respond number 2. Now the land has been, 10 acres has been purchased by him from my party. And subsequently, along with the 10 acres, she has offered another 10 acres, 22 acres from me by using a forged sale deeds. That was subjected to inquiry. No more inquiry officer said it is a forged document. Subsequent lordship has referred the matter to the reference court here. Reference court has determined that issue as to who is entitled. The sale deed relied upon by my friend do not confer any rights because it is an unregistered sale deeds. Unregistered sale deeds. Now, compensation is received. Even her documents has been seized by this honourable court since the proceeding is arising from the PIL. Therefore, my lord, there is one issue is left out by the learned reference court is that who entitled, my lord, that is given relegated to the collector. My lord. To that aspect, my lord may remand back to the district judge, the reference court, to determine that aspect and give a report. And lordship can take a final
Because
decision.
there will be no end to this. As I humbly submitted,
It
my
is
lords,
not answer.
if my lords, any of us have a title over the property, we would have to go and establish it before a civil court by leading evidence. Even including the question which my learned friend is saying, my lords, that if at all that sale deed did not confer any right, title or interest upon me, that would have to be determined in a trial, my lords.
The issue referred by
The issue here is, my lords, I have pointed out at paragraph 4, insofar as State Dakar is concerned, my lords, she had gone before the Supreme Court at the first instance. The first order I have not pointed out at page 1, that had been rejected. Subsequently, my lords, the categorical observation of the Supreme Court saying that we cannot go into the question of her right.
You say to be kept for another 3 months. Then if anybody comes up with a contrary order, so it will be.
Look at page 1 of this compilation.
So please listen to our order. I think it will suffice.
But if I may, either way, whatever is the finding of the reference court has come, that some of us are aggrieved by that. We should have an opportunity, either in this instant proceedings before your lordship will we come with our response, or otherwise we may be allowed to go on, assail it according to law on appeal and all.
So you have not done either of the two.
So that is what we.
Yes, please listen to our order. We have gone through. No, we have examined in detail. The order dated 2nd August 2017. In SLPC number, this civil flag B. Belinda Lapang and others versus the state of Meghalaya. Paragraph. The crucial part of the said judgment and order is reproduced below. Internal page 4 of the judgment, running page 5 to 6. Further to our earlier order, the learned Special Judicial Officer, East Khasi Hills, Shillong, started LA case number 1 of 2025, Srimati State Decor and others versus the collector, Ribhoy District, Nongpo. She pronounced a judgment and order on 20th, 20 June 2025. The learned judge inter alia held that the compensation of rupees 115 only offered was not excessive and had been calculated as per section 26 of the Act. This is 115 per what? Square foot?
Per square feet.
115. After that, you write in brackets square foot. Mr. Paul, why are you appealing against this order? Why are you appealing against this order?
We are aggrieved because of a simple reason, Milits. I am saying that this settles the issue insofar as compensation is concerned. Insofar as claimant 1 and claimant 2 is concerned, Milits, the court says, claimant 2, it says, Milits, that claimant 3, that it does not confer any title. Insofar as, Milits, at B, regarding that 26 acres, Milits, is where I come in. Because I am the person who's been paid the compensation, Milits.
You want more?
No, I am saying, Milits, give me my 20%, Milits, I am okay with it, I am off.
That is why the appeal.
Milits.
Because she has said nothing about 20%.
No, Milits. I am only saying, Milits, there has to be a quietus to the matter. If anybody is aggrieved, Milits, we can go and agitate the matter before a civil court. Because the third finding at C, Milits, goes against the very concept, the very acquisition itself. It says that none of the lands are contiguous. It could not have been done. And at D, Milits, she says that there has to be a fresh survey.
With great respect to my friend, the second issue framed over the Supreme Court is not answered by the reference court.
The
request for the examination by reference court.
The appellant is the transferee stroke buyer of the land. No, the appellant is the transferor of the land and has received 80% of the compensation payable at the above rate. Full stop. This appeal has been preferred inter alia to claim the balance 20%. Paragraph we find from a scrutiny of the said order of the Supreme Court no, please take out this one. The contention of the respondents is that the amount of compensation received by the appellant is far more than the amount receivable according to the appellants. No, according to the appellants, the respondents do not have any stake in the property. Next line, quotation. Question as to who is entitled to compensation may also require consideration. Unquote. This was another direction in the said order of the Supreme Court. Paragraph. The learned judge in the earlier I have said preferred an appeal from this order. Have have brought out this issue in the public interest litigation itself.
Proceedings.
Okay, now continuation. It is true that the learned judge has made no determination on this issue. Paragraph. The records are not before us to apprise us whether the question of entitlement was at all taken before the learned special judge. Paragraph. Rejected. No, it has been determined.
Which is what Malaja is submitting. If the lordship's direct. I was saying that whoever is aggrieved, Malaj, can go file a civil suit, get a declaration, and then Malaj, the remedy would be
This
there.
reference, because the matter went on reference, that itself was a civil proceeding. So against the civil proceeding, legal recourse, either an appeal or, but because the matter is pending before your lordships now, so we were prevented from going.
We've none of us have taken a lordships. I'm saying that liberty may be granted to all of us to seek legal recourse.
Legal recourse, as long as this is pending here, my lord, we are not in a position to go on appeal because the Honorable District Judge has, reference court has sent the report here.
Which?
Humble submission, my lord. The second issue is not decided. It is addressed by the reference court. It requires press examination at the reference court.
What? Which
The
is
second has to who indicts,
which?
My lords, what my friend wants is, my lords, a de novo inquiry on the same issue. That cannot be permitted.
No, what is the issue? It is not referred by the Supreme Court.
My lord, no, my lord.
It is not.
So
you cut that out?
That was not addressed by Supreme Court, but allow all the parties to
This issue as to entitlement of compensation has been carefully gone into and determined by the learned single judge, by the learned district judge. Yeah. Paragraph. We only observe that this reference was in a public interest litigation. Further, to reference to the learned special judicial officer East Khasi Hills, Shillong, who is also by designation a district judge, was further to an order of the Supreme Court in a public interest litigation. Full stop. It was not a reference under section 26. What is that act? Land acquisition?
Well, it's a new act.
2013?
Sorry?
2013 Act, my lords. It will be under the new Act.
It's section 64.
Section 64 of the new Act is, my lords, corresponding to that old Section 26.
And 26 also, market rate determination.
That is calculation of the market rate, my lords. The finding is at F, my lords, which is as in terms of Section 26.
Is under, you said section 80?
64, my lords.
64 read with section 26 of the right to fair compensation and transparency in land acquisition, comma, rehabilitation and resettlement act 2013. Paragraph. In those circumstances, we treat the judgment an order dated 20th June 2025 as a final judgment stroke decree made by the learned district judge in the exercise of her original jurisdiction. Any party aggrieved by the order or any part of the order shall be at liberty to take steps in accordance with law.
In accordance with.
Full stop. We only clarify that the 20% of the compensation amount which is withheld by the state will continue to be withheld for a period of 8 weeks from date. After which it shall be released to the appellant.
But
From all this pages, one prayer. And since may not be
8 weeks, appellant, comma, if no contrary order.
and may pray.
If there is no order to the contrary.
It's only one prayer, we Lordship.
Yes.
Your Lordship, direct the limit number 2. If deposit the 80%, he withdraw before the registry office will call. And the parties may resort to regular appeal. And whoever succeeds.
80% he will deposit.
my lords,
The regular court has determined that he is entitled to.
my lords,
And
all,
you have
all these issues, my lords, the Supreme Court has dealt with in 2017. We can't open these things up at this stage.
I entitle my.
He'll have to go before a competent court to establish it.
all right.
Because by using a fraud document, fake document, he has withdrawn. And the Nopo God and Shillong God said she is not entitled. She is not entitled. Therefore, for fairness of things, my humble submission is you Lordship direct him.
They will have to
The,
approach.
80%.
the period between 20th June 2025 and the pronouncement of this order shall be excluded for the purpose of shall be excluded in calculating
Limitation.
the time taken to prefer an appeal by any party,
But
comma, for the purpose of limitation.
these proceedings may be closed, my lords. This miscase can be closed.
This public interest litigation is accordingly disposed of.
It's a miscase in the main PIL, my lords.
All are disposed of.
Main case, my lords, the larger issues of the PIL are pending, my lords. I'm not
All
updating
right.
this.
This miscellaneous case is disposed of.
That's highly.
Number 10.
Yes. Yes, please. Continue for some time, if you like. Or we will keep it next week.
Next week, I have little language.
Mr. Khan, have you finished?
No, Lordship. The before yesterday I said, Lordship, there's one more last point left. Maybe I'll just take 10-15 minutes to just close my argument because that's a very important point. I'll take just 10 minutes to conclude that point.
Yes.
Lordship, just to refresh that, I had concluded my first argument on the inculpatory part and the relevant laws. And the second part, Lordship, is the statement made by the accused under 164, Lordship. So I have made a distinction between confession and statement. Confessions are proved under Section 80 and then statements are proved, Lordship, under Section 17 of the Admission Act.
Yes.
Her statement that she went outside, her husband went outside and then he collapsed. And this will be protected within the meaning of section.
No, prosecution's witness was cross-examined, not cross-examined.
Cross-examined, Lordship.
He was not cross-examined. Your witness was not cross-examined.
No.
The defense put up any witness.
Defense could have brought, Lordship. Defense could have brought under 315. They never brought any witnesses.
No witness at all.
At categorical statement in 313, she will not lead any evidence. So once Lordship.
Not she, not through any others.
Not through others.
No evidence. It's recorded.
Absolutely on record.
Statement in court.
Lordship, yes, in 313. Question, Lordship, I've read out the other day. Question number 16, Your Lordship. I'll just take it hurriedly, Your Lordship, again, just to refresh your court's mind. That is at page 89.
Page 89.
89, question number 16.
Yes.
So, Lordship, once she chooses not to lead herself as a witness, as a defense witness, or any other witnesses, then there is a consequence, Your Lordship. First, Your Lordship, the principle of waiver will come, that she has waived her right. Second will be, Lordship, she is stopped from questioning anything because her conduct shows she is happy with what happened. And the logical consequences, Your Lordship, the principle of acquiesce will be applicable. She accepts whatever has happened in the prosecution, she accepts because she doesn't want to bring anything to rebut. If that is the position, Your Lordship, estoppel, waiver, when acquiesce, then the issue, Your Lordship, is this: her statement is governed by Section 17. If I come back to page 35 again, confession is closed, admission, Your Lordship, has been proved in 1, 2, 3, supported by inquest, post-mortem, and PW5, the seizure. I've also submitted on the dagger part.
We have understood, Mr. Khan, against
Lordship.
Such a weak accused, your case is absolutely bulletproof.
Lordship.
Nothing, invincible. We would like to hear Mr.
Only the last part, Your Lordship. The last part is very important because the exculpatory part, Your Lordship. This is where I'll just take 10 minutes, Your Lordship, before I conclude my hearing on the merit.
I don't think it is required, Mr. Khan.
Lordship,
it is so strong.
But this is very important, Your Lordship. Why this, Your Lordship? There are two sections that Lordship will just come to page 35. Lordship, from the top, the sixth line. Insofar as the death of the boy is concerned, Your Lordship. This is the exculpatory part of the statement of under 164. My 4-year-old boy was having a rice and my late husband hit the boy's neck from the left side 3 times. My son just slumped to the floor. So this part, Your Lordship, this portion is otherwise known as exculpatory statement. In other words, regarding the death of the boy, she clearly says in a confessional statement, she excludes herself and she pinpoints as to who killed the boy. Lordship, rarely, maybe for a prosecution counsel, Your Lordship, we get an occasion to have such kind of a situation in a 164 statement. Now, I'll just take Your Lordship, how do we address this particular issue? If I may submit, Your Lordship, for a prosecution to prove a case, under 101, prosecution has to prove the case beyond reasonable doubt. That flows from 101 of the Evidence Act. No, 102 is a very important provision, Your Lordship.
No, Mr. Khan, please try to appreciate. We are also trying to do it. If the accusation is for 2 murders, it doesn't matter if it's an exculpatory statement for one, because it is followed by an inculpatory statement with regard to the next.
Absolutely, Your Lordship.
So the result is the same.
Lordship, I'm only on a limited purpose, Your Lordship. Lordship, I'll just take Your Lordship to 106.
This alleged exculpatory remark
Lordship.
or statement will take her nowhere.
No,
because she admits or confesses to the next one as per the statement.
Yes. But why this is very important, Your Lordship? Your Lordship is slightly a difficult argument. I understand, Your Lordship. I'm just trying to make myself clear, Your Lordship. Why I'm trying to rely on that? I'm making a preemptive attempt as to who should prove this. The prosecution has to prove the case, Your Lordship, beyond reasonable doubt, and their burden never shifts on the defense. In fact, Lordship, if I may add, there is no need for this Honorable Court to hear the defense counsel. No need at all. The role of a defense counsel is only to prove there is a doubt. The burden never shifts on him. Now, this is the statement where the burden shifts, Your Lordship. Lordship, for a moment, I'll just take Your Lordship to 106 of the Evidence Act. The moment she says that the husband killed...
is about special knowledge.
Lordship, yes, special knowledge. 106 is special knowledge.
Yes.
And special knowledge as to what happened within. What happened within the room, her knowledge is that she confesses of hitting the husband. The exculpatory part of what happened, how did the boy die, prosecution cannot get any other witness, Your Lordship. The only witness, the only statement which is very relevant is, what did she say? Had she not made this statement, Your Lordship, the burden would still have been on me. That's why, Lordship, I said this is slightly a complicated argument. Allow me just to make it as much as possible, Your Lordship. Because this is the issue of a death of a boy. The moment she says this is her knowledge and she says this, the burden of prosecution, this is otherwise known, Your Lordship, in law, the reverse burden. And Your Lordship, can you allow me to just read 106?
Yes.
So far this statement, exculpatory statement is concerned, the burden is shifted. Lordship, this flows from part 3. Lordship, we just come to the first to 101. Just to appreciate, Your Lordship, the shifting of the burden. So, part 3, production of the effect of the evidence of the burden of proof. 101, burden of proof, Your Lordship, is always with the... Now, on a particular fact, on a general specific knowledge, she is stated in an exculpatory statement regarding the death. Now, that comes within her knowledge. And 106, Your Lordship, if I may just read 106, Lordship. Where any fact is specially within the knowledge of any person, the burden of proving that fact is upon him. Within the knowledge, the exculpatory part regarding death of the boy is within her knowledge, and the moment it is within her knowledge, which is fortified by 164 statement, the burden is on her to discharge that this was proved. No, immediately Lordship I'll have to correlate this shifting of burden with 315. If she has to prove, then she had to lead evidence. She had to lead evidence. And Your Lordship, if she, admittedly there is no evidence led. And if she is no evidence led, what happens to her statement? Lordship, the court has to presume that she has not discharged the burden of proving. In other words, this statement, exculpatory statement, implicating the deceased husband who was dead as a murderer, stood disproved because the burden was on her and she chose not to prove anything. The moment this happens, Your Lordship, immediately 114 of the Evidence Act, Your Lordship. If the situation is such regarding a particular fact, then what will be the role of such witness, Your Lordship? Will you just take Your Lordship to 114?
That is act done in regular course.
Lordship, but just I won't take much time, Your Lordship. I'll just like to conclude here only. Court may presume existence of certain facts. Lordship, this is a provision, of course, it generally does not apply, Lordship, but court may presume, the power of presume, if the burden has not been discharged. For example, Lordship, if my burden under 105 was not discharged, immediately the other principle will be activated, the benefit of doubt principle which benefits accused. In this case, if the reverse burden is not discharged, it is not the case that I will get a benefit of doubt as a prosecution, a complicated legal argument, Your Lordship. But court will presume, since you have discharged, you have not laid evidence under 315, and the post-mortem reports, the inquest report clearly shows that there was a death inside and you had a special knowledge and you chose not to discharge, court will presume that it is a false statement. And if it's a false statement, Your Lordship, if it's a false statement,
Yes.
then court will infer, since you have not discharged a debt and the burden was on you, the court will presume that you had caused the death. And Your Lordship, if Your Lordship will allow, the post-mortem report will clearly show that she had killed. Prosecution document will show that, Your Lordship. Just for a moment, if Your Lordship will. I'll take straight to the post-mortem report, Your Lordship. Her statement in page 35, Your Lordship. Her statement in page 35 is, my 4-year-old son was having rice and my late husband hit the boy's neck. Lordship, hit the boy's neck from the left side 3 times. She chose not to prove by 315. Now we have a post-mortem report. Let us test this particular statement. Whether if this is correct, then the cause of death is not proved by her, but it will still shift on the post-mortem done by the prosecution. Hit the back of the neck on the left side 3 times. Lordship will straight come to the post-mortem. I'll just take a Lordship to the...
Not required, Mr. Khan, because you have tendered the post-mortem report. Nobody has contradicted
No, but this particular fact, Your Lordship, it contradicts. This particular fact of hitting 3 times from the left, it's not there in the post-mortem. She hit it and she's made a false statement.
No, but the post-mortem report is proved as an exhibit.
Regarding this particular fact, let us just test this proposition, hitting in the neck with the left side for 3 times. Only for that purpose, Your Lordship. Lordship will come to page 45. Her reverse burden she is not discharged, but the post-mortem proves otherwise. The purpose is that post-mortem proves that it was thou that killed, not the husband. Page 45. external appearance, Your Lordship. Her statement is hit the boy 3 times in the back of the neck. Lordship will come to the external appearance. Condition of subject stout, emaciated. Lordship will just come to the second table. 2 wounds, position, size, and character. Lordship has got it. This is the postmortem of the boy. 1 cut wound at the forehead. Her statement is at the back of the neck, 3 stabs. 1 cut wound at the forehead. Second, injury back of the neck. So 1 cut wound at the forehead directly contradicts based on medical examination. In other words, stabbing 3 times in the back of a neck in an exculpatory statement. Stutz proved. Lordship,
Yes.
last, why she's making a false statement, Lordship, again, Lordship will take your Lordship to.
It's all right, Mr. Khan. This is more becoming an academic class now. We have understood. That's all.
Lordship,
Finished.
we
have
only
understood.
this part was relevant,
You see,
Lordship.
Section 164 has some weight. The evidence in court has much greater weight. Evidence in court has been read by the prosecution, not cross-examined, followed by postmortem report, which is tendered in exhibit. So he is called upon to explain why the accused should be acquitted or the sentence should be mitigated or commuted.
Lordship, absolutely correct.
Yes.
Lordship was saying.
On the next day,
Next day, Your Lordship.
what is your defense, Mr.
My defense is that, Your Lordship, the postmortem report is inadmissible. I mean, confidential statement is not admissible at all.
That you have said. Then,
No, I'll prove it also. I'll
Then-
come by the proof with a citation, everything, Your Lordship.
then secondly,
Secondly, that the learned court below has misread the entire evidence, Your Lordship. There won't have been a conviction at all. This is not a case of conviction at all.
why?
Obviously, Your Lordship, what has happened inside the room, nobody knows. And another thing, for a moment, if Your Lordship looked up confidential statement, she had never confessed anything before the magistrate.
Then what about that seal and signature?
3,
Seal and signature. Both.
What about the seal and signature?
seal and signature, Your Lordship will see that in 2 places thumb impression has been taken.
How do you get that?
Yes, I have obtained it from the paper book, Your Lordship. It is there in the record. Your Lordship will see that page 33. Page 33 of the paper book, Your Lordship.
Anything on oath?
Yes, confidential statement taken on oath. This is a prohibition, specific prohibition under subsection 5 of section 164, Your Lordship. Even Apex Court said no confession can be admissible under oath. The moment taken oath.
When, Mr. Khan? Convenient for you?
Sorry, Lordship.
When is it convenient for you?
Because I think
Next day? Tuesday?
Tuesday, Lordship. Only on law points.
Tuesday, Your Lordship, I believe, can it be on first week or on 4th, 5th, 6th?
Let him go. You want to cite some cases?
Lordship, yes. At least 4
How much
judgments.
time you will take?
For judgments, Your Lordship, only the relevant operative part, Your Lordship. I won't take much time.
Half an hour will do?
Half an hour, yes.
So, can it be on 4th, 5th like that? If no inconvenience to Your Lordship, because I have some difficulties, Your Lordship.
4th and 5th is a long, try to do it before that.
Lordship, maybe next week, if I can get half an hour, I'll just conclude my part of the judgment. On facts, I'm concluding. And he's given me the list of judgments, Your Lordship. So I have all the judgments that he's relying, and I am sure he's have my judgments too. So I'll just try to wrap up.
Can it be on 30th, Your Lordship, then?
All right.
30th.
Mr. Khan, learned advocate, additional advocate general concludes his arguments. Facts. List this appeal on 29th July. For Mr. Khan to argue on law.
No, Lordship. 30. 29. When?
Mr. Khan, don't take us otherwise.
No, absolutely.
Because you know this game of cricket. Game of cricket.
Absolutely.
Once you have put up 400, 500, 600 runs in the board, there is a cry, declare. We want to see the other side. So we were just calling upon you to declare.
No, absolutely. Like, I was trying my best to assess Your Lordship because
And not to aim at 700, 800, which may be impossible for the other side to chase.
I was trying, Lordship, to assess the court because the nature of the case is such, Lordship. You know, where had the prosecution exhibited, the witness magistrate would have come before the court. I would have not taken so much of time. Oblige.
Deeply obliged.